Hey everyone, it's Alex Kukulici here, president of FSU Mock Trial in the 2014-2015 year. Jesse Duran versus, or I guess Park v. Duran is the case. We're here talking about rules of evidence basics. On this rendition, we're going to talk about hearsay, its definition, and exclusions to hearsay, namely statements that are not hearsay. To get going, we're going to take a look at the rule. I'm going to pull it up right here. So here's the rule that we're going to be talking about. It's Rule 801. The 800s deal entirely with hearsay and nothing else. Despite the fact that it's a singular objection, there's a lot of complexity to it. Most people say it's the most complex legal definition when it comes to rules of evidence that you need to know. But hopefully we'll try to make it easy. We're going to be focusing specifically on Rule 801. 801 defines what hearsay is. And by defining what hearsay is, it makes some statements as to what hearsay isn't and what is not inadmissible as hearsay. So rather, what is admissible as not hearsay. Let's take a look and read what it says. First, there are a few definitions. A definition of a statement is that it's a person's oral or written assertion or their nonverbal conduct, if the person intended that conduct as an assertion. What this means is things like shrugs, head nods are hearsay because they are nonverbal conduct meant to assert something about various statements that are done. A declarant is the person who made a particular statement, not the person who's testifying to that statement on the stand. And then hearsay is one, a statement that was not made under oath, and two, a statement that is offered into evidence to prove the truth of the matter asserted in the statement. It's kind of a mouthful, and I dislike how it's presented in these rules of evidence. So when you're thinking about hearsay, I want you to think about it like this. Hearsay are out-of-court statements that encapsulates 801c1 that we're talking about here. So hearsay are out-of-court statements offered for the truth of the matter asserted. Now, offered for the truth of the matter asserted is a mouthful. It's not necessarily the easiest thing to grasp what the truth of the matter asserted in a statement is. We'll be talking about that very briefly before we move on. But it's important to know that hearsay is one of the rules that you want to argue within the context of the language provided. The reason being that even people who aren't prominent criminal attorneys, they don't use the rules of evidence very frequently, they probably had to take evidence in law school. And even if they didn't, they had to take evidence on the bar. And the phrase truth of the matter asserted is a trigger word when it comes to getting people to remember that you're talking about hearsay and to remember just the general outlines of what is and isn't admissible. So let's break this down even further. The statement is defined, declarant is defined. Hopefully those just make some intuitive sense. But when we're talking about the specific words within the hearsay definition under 801c, the purpose of hearsay, taking a step back, is to ensure that statements that are being brought into evidence are reliable. Namely, statements that an individual heard from other individuals tend to not be reliable. If you've ever played the telephone game when you were a kid, the message gets distorted just slightly by every single person who hears the statement. By the end of the chain, the statement isn't recognizable. It doesn't mean the same thing it meant at the beginning. Because of that, hearsay has some inherent unreliability, and as such, there's these rules in place to ensure that it is reliable. That's why 801c1 exists, because hearsay, or statements rather, that were said in court are assumed to be true. They were sworn under oath. There are usually plenty of witnesses. They're very reliable statements. So if a statement was made in court, or at the very least in the current trial, then it is not hearsay, because everyone was there to hear it. So if you're calling Danny Brooks in this case, and let's say there's no sequestration, so Danny Brooks got to hear what was said before, Danny Brooks can make a comment on what Andy Park might have said earlier in the trial. This is more often done with defendants commenting on what people have said about them over the course of the trial. And that's okay, because those statements that they're repeating aren't hearsay under 801c1. So when we're looking to try and preserve the reliability of the record, we look to these hearsay rules when it comes to out-of-court statements. So now it's the fun part, and it's defining what truth of the matter asserted is. So for a statement to be hearsay, it has to assert something, and the purpose that the statement is being offered into evidence needs to be to prove the matter asserted in the statement. To give an example, if you have an expert witness who says, it doesn't have to be an expert witness, let's just take any witness. John said the light was red. If you are offering this statement from whatever random witness about what John said, and the purpose of the statement is the purpose of entering into evidence is to try and prove that the light was red, then that's hearsay. Because the truth of the matter asserted in the statement, that light was red, is that the light was red. And you can offer the statement that the light was red for other purposes besides trying to prove what color the light was at the time. Namely, we don't care what color the light was, but let's say you care about what John thinks the color of the light was. Maybe his mental state at the time of the incident either absolves him from culpability or makes him more guilty, depending on whatever you're trying to argue. So let's say if John, regardless of whether the light is red or not, if John thinks the light is red and he runs that red light, then he's liable. So you can offer the statement, well, John said the light was red, not to prove whether the light was red or not, but instead to prove what John's mindset was at the time. It's an alternate purpose. Stuff like this is going to get covered later on in the 800s. There's a laundry list of exceptions under Rule 803. I believe it goes as high as 24, 25, 26 enumerated exceptions to hearsay, one of which that is one of them. But hopefully that gives an example of when statements are not offered for the truth of the matter asserted. The most common time you're going to be using the definition of hearsay right here in the course of an objection argument is with one extremely common response, and that is effect on the listener. What this means is that if you take the same statement, John said the light was red, you might offer it to show what John's mindset was at the time. You might offer it to show that the light was in fact red at the time. The latter wouldn't be admissible, the former would under an exception to hearsay. But another reason you could offer that same statement to evidence is to show what Sue, the driver, did as a result. So when John said the light was red, Sue broke the car immediately. And in doing so, an accident happened where a car behind Sue collided with Sue's vehicle. You're not offering that statement for the truth because you don't care whether the light was red. You're offering John's statement that the light was red to see Sue's reaction. And as such, because the purpose of the statement is different, it doesn't meet the definition of hearsay. So when you're talking about hearsay and whether something is or isn't hearsay, the purpose for which it is offered, not necessarily just the content of the statement, can have an effect on its admissibility. What that's called is effect on the listener. If you're offering a statement to see somebody else's response to it, then that's perfectly okay. And it doesn't meet the definition of hearsay, and you should say so in your objection response. Caveat, when you use that exception, beware that some people will not allow you to elicit the specific content of the statement if all you're looking for is the reaction. To go back again to the red light example, John says the light is red. Sue breaks the car immediately. In doing so, an accident occurs. The purpose of offering the statement is to see Sue's reaction. Some judges, I don't think it would happen in this case, and some other teams will argue that the content of the statement isn't important if all you're trying to elicit is the reaction. And sometimes that's a compelling argument to make. So when someone uses effect on the listener, a common response can be, if all they want is the effect this had on the listener, then they can elicit that effect, and they can elicit the fact that a statement was made, but not the specific content of the statement, just so you know. So that goes over the definition of hearsay and how certain things can and cannot be hearsay as they fit into the definition under Rule 801C. 801 also covers some other types of statements that aren't hearsay. And those are covered in 801D1 and 801D2, which we have right here. And I'll scroll them up to be the top of the page. Just for reference, and this is how relevance works as well, 801 defines hearsay, says certain things that aren't hearsay. It's Rule 802, though, that says that hearsay is not admissible. So 801 defines, 802 bars testimony meeting that definition from entering the record. Same thing with relevance. Relevance is defined in 401. Irrelevant evidence is barred under 402. Anyway, under Rule 801D1, this deals with a declarant witness's prior statement. So almost always, this is going to be used as the foundation of impeachment. And we'll talk about impeachment and the rules that underlie it more specifically. But that's the extent to which I think 801D1 is explicitly necessary. There are other uses, especially in real life. It's much more important, and it happens more often than you'd think. But that is essentially the gist of 801D1. Namely, 801D1A talks about prior inconsistent statements. 801D1B talks about a declarant witness's prior consistent statements. The real important thing here, though, and something that comes up in every single case that exists, including in mock trial, and it happens very frequently in mock trial, 801D2. A statement is not hearsay if offered against an opposing party and was A, made by the party in an individual or representative capacity, B, the statement is one in which the party manifested or adopted a belief in the truth of the statement, and C, was made by a person whom the party authorized to make a statement on the subject. That's something called agency, which D applies to as well. We'll talk about those later. They are less important. And E, made by a party's co-conspirator, not relevant in the Park v. Duran case, very rarely relevant. There's a lot of underlying really interesting law behind 801D2E. But what we need to focus on is 801D2A and 801D2B. 801D2A means that your party opponent, their statements are not hearsay. The idea being that even if a party opponent's statements might have some inherent reliability, they are so important for reaching a proper judgment in the case that perception or perhaps unreliability can be waived for the sake of admitting it in all cases. This means that for the defense, the party opponent would be the plaintiff. In the Park v. Duran case, Andy Park is the party opponent. On defense, all of Andy Park's statements get in automatically. This applies to children as well, and this kind of is rooted in C and D, which are the rules of agency, but it doesn't apply directly. Namely, technically in this case, Sydney Park is the plaintiff, but as she is deceased, Andy and Lee Park are pursuing the case on her behalf. As such, Sydney Park is a party opponent. For the plaintiffs, their party opponent is the defense. So Hayden Duran and Jesse Duran, because minor children are considered their parents when it comes to evaluating hearsay. So anything on the plaintiff side of the case, when a plaintiff attorney is talking and trying to elicit testimony, if they're attempting to elicit a statement by either Hayden or Jesse, then those statements are okay. And as such, they are not hearsay as admissions by a party opponent, even if Hayden Duran, the defendant, didn't specifically state the statement and it was Jesse Duran instead. It doesn't matter. That applies in this case particularly from the statutes, which we'll go over more in depth in a later video. But just so you know who qualifies as party opponents in this case, and you can extrapolate that out to cases in the future. Something I want to mention for 801 D2B. Very important. It doesn't come up very often, but it does sometimes, and there is an instance in this case where it does. Statements by a party opponent don't necessarily need to be authored by a party opponent if the statement is one the party manifested that it adopted or believed to be true. The shorthand, and you could barely call it that, is manifesting a belief in the truth of the statement. So the example from this case, I'll just use very briefly because it's a good example, is, and this applies to almost every instance of a signature. Hayden Duran signs a document. And by signing the document, admits to having read the document at the very least, or having had received the document. An argument can be made that by signing a document, especially when it comes to a contract, the person who is signing has manifested a belief in the truth of the statements contained within. The document that Hayden Duran signed in this case is a disciplinary notice from the school, not authored by Hayden Duran, but Hayden Duran admits to having seen it and to having signed the document. As such, you could argue that Hayden Duran manifested a belief in the truth of the statements, and even though Hayden Duran did not author that disciplinary notice, it could be admitted as not hearsay because the party opponent manifested a belief in the truth of the statements within. That's an example of when 801 D2B is useful, and signatures tend to be the most common way, at least that I've seen, that comes up. Rule C and D, I'll talk on them briefly. These are the theories of agency. These come up when you have companies, namely any employee of a company, and the D explicitly mentions this. Statements made by those employees are attributed to the respective company. And that applies not only to their statements that they made, but to knowledge individual employees might have had, et cetera, et cetera. So that's the theory of agency, that the corporation is responsible for the actions of its individual parts. C is kind of meant the same way. It's a bit more broad, though. It's if Hayden Duran allowed, I think maybe the best example from this case is Andy Park and Danny Brooks. Perhaps an argument could be made, well, that one, Danny Brooks was an agent or an employee of Andy Park. Perhaps there's an argument there under 801 D2D. But you could say under 801 D2C, by allowing Danny Brooks to watch over the children, Danny Brooks' statements and commands to the children while Danny Brooks was babysitting could be considered statements by party opponent under 801 D2C, because Danny Brooks, by being allowed to babysit, being told to babysit, was given authority by the Parks to act in that sort of caregiving capacity. And as such, those statements made in that capacity are party opponent statements. That explains, I hope, 801 D2 in more depth. If you have any questions, let us know, and we'll be delving into more of the rules, especially into hearsay later on. Thanks for watching.